Hi, I am Tom Daly. I'm a partner at Roca Rothgerber Christie, and I practice in the intellectual property practice group.
And I'm Drew Wilson. I'm an attorney at Roca Rothgerber Christie, and I also practice in the intellectual property group.
And today we're going to be talking about various different ways that you can protect the outward appearance of a product. I mean, it has to be a product that's going to be around for a long time.
Yeah.
Because trade dress can potentially last forever, but it takes a while to get to the point where you've acquired distinctiveness. So you don't have it right away. So it needs to be a product that's going to be around for a long time. You know, like the Coke bottle has been around for a long time. It's a classic. But if you're talking about an item like a aftermarket wheel, where the aftermarket wheel is going to be hot and everyone's going to want it. And then after a few years, they're going to have new styles coming in. And so it's not particularly going to be appropriate for that type of product because, you know, by the time you have acquired distinctiveness, you no longer have a product that has a big demand in the marketplace.
You know, that's a really good point, Tom. And I'd like to add to that to say that really the products that work well with trade dress are products where the overall product configuration is something that's unique and identifiable. So for example, I mentioned in a previous video that color is something that's protected by trade dress. Well, in the color context, it's the entire pad for when you're doing a dry cleaning, or it's the entire sole of a shoe. It's really something that catches the eye, that customers associate that particular feature, the shape of the Coke bottle, with a single source provider. There's a number of advantages of trade dress protection over other forms of IP. One that immediately springs to mind is the fact that you can obtain trade dress protection for things that you couldn't necessarily get a copyright or a design patent for. For example, you can obtain trade dress protection for the color of a product. You can obtain trade dress or trademark protection for things like the sounds that a product might make. Even smells are protectable. And that's really unique to trade dress and trademark law. Another advantage that you can get from trade dress and trademark protection is that the trade dress and trademark protection is infinite in duration. So long as your company is actively using the trade dress, you have rights in it and it stays protected. I believe there's one particular registration that's well over 100 years old, and you can't find that with any other form of IP. The final form of benefit for trade dress is that injunctive relief, once you've demonstrated a likelihood of confusion, is all but guaranteed. There is a presumption of irreparable harm, which is one of the elements of an injunction that is with trade dress, but with other forms of IP, it's not necessarily guaranteed. So you can stop an infringer from using your trade dress a lot easier than other forms of intellectual property.
One of the problems with trade dress is that it is relatively expensive in the context of protecting a product because you have to show secondary meaning. The trademark office makes that difficult to do, so it takes a lot of effort. Takes some time, so that's one of the disadvantages. Another disadvantage is that when you have trade dress protection, you have to use it to maintain that protection. So it has to be an ongoing, product design that you're always going to have. I mean, the Coke bottle is still around, still going strong, and so it's great for trade dress protection. But if you're going to be getting rid of the design next year or the year after that, then trade dress really wouldn't work. Another problem too is the damages that you can get when you have a trade dress type of protection, a registration. That registration is primarily going to give you injunctive relief, so you can stop people from copying, but you're not normally going to be able to recover substantial damages. Only if it's a counterfeiting type of situation or a willful infringement situation will you have an opportunity to recover damages. So you don't need to have a federal registration to have trade dress rights. There are state laws that protect trade dress rights. You also have common law rights. There are benefits to getting a federal registration, but you don't have to have one. Still, you do need to have acquired distinctiveness. People have to associate that trade dress with a particular source before you have any protectable rights. So regardless of whether you're relying on common law or a state registration or a federal registration, you have to have that acquired distinctiveness.
There are a number of benefits for a federal registration for trade dress. Number one is a presumption of validity, that it's presumed that the trade dress is a valid trade dress that has secondary meaning. Along those lines, the presumption of secondary meaning is another benefit. As we discussed in an earlier video, secondary meaning can be very hard to prove. If you have to wait to trial to prove secondary meaning, you might have to engage the service of an expert that could cost $70,000 to do a nationwide survey. Another benefit is that it gives nationwide notice to anybody else who might want to use the trade dress. Trade dress gets listed in the Federal Register. People can look it up when they're wanting to register their own trade dress. And so you sometimes don't even realize how many instances of infringement are avoided simply by having the registration to begin with. Finally, you've got the ability to register your trade dress registration with Customs and Border Protection. And that gives you the advantage of having the federal government on your side, preventing imports from China and overseas that might contain products that would infringe your trade dress rights. It can be very difficult to obtain a federal registration for trade dress. There's really two types of trade dress registrations. One's for the product configuration, which is what's germane to this topic, and one's for things like restaurant layout. The problem with product configuration is that you have to prove secondary meaning and that what you are trying to protect isn't functional. And in order to do that, you very often have to engage the use of experts. Sometimes you have to conduct surveys to show that people have begun to associate the product with the particular company who's applying for the registration, and that can be very expensive. Sometimes you can also do things like show that you've been in a substantially exclusive use of that product configuration for at least 5 years. If you can get away with that, if the examiner allows that, it's a much cheaper way of getting the registration.
So we've been talking about how it's difficult to get trade dress protection because you have to show this secondary meaning. Clients can actually make it easier on themselves to get that protection if they focus on the trade dress in their marketing. So if you tell people, for example, when we were talking about color and how color as a trade dress can be protectable as soon as it has secondary meaning, if you advertise, look for the pink fiberglass or look for the, this particular characteristic of the product in your marketing campaign, that will help show that that feature is in fact intended to be a source identifier and a trademark.
That's a really good point, Tom. And I think it's also important to note that the client really needs to make a consistent use of whatever it is that they want to protect as trade dress. They can't go changing the shape of the Coke bottle and then claim protection on whatever the shape is at the time. There's a reason that the Coke bottle has that iconic look that's been around for well over 100 years.
And because functionality is an issue, clients should stay away from claiming that something is functional. So if you claim that the color is important and that it has a function, that would take away from your ability to get trade dress protection for that color. So when you're trying to protect the appearance or the configuration of a product, if you rely solely on trade dress, the trade dress is one of the more difficult forms of protection. It takes time to develop secondary meaning, which is what you need to be able to get trade dress protection. So it ends up being expensive and tougher to get. So you want to try and find other ways to protect it that are maybe a little less expensive, a little easier to get.